Hey, good evening, everyone. My name is Thane Rosenbaum. I'm the creative director of the Forum on Life, Culture, and Society at Touro College. And in partnership with our longtime producing partners, the 92nd Street Y here in New York, welcome to our annual series, Law of the Land, the Supreme Court's Year in Review. This has become a surprisingly, almost absurdly popular program. When Susan Engel and I from the 92nd Street Y thought of this thing 7 years ago, we thought, would anyone be interested in this? And it just every year, more people sign up. When we did it live, people showed up, and the vast majority of people are civilians who did not go to law school, which makes it much more fun. Our style at 92 Talks, and as well as at FOLCS, is conversational, funny, witty, and smart. And so we can even do that with the Supreme Court. Just watch. Before I introduce our guests for tonight, if you have a question for any of us at the end, you can leave that question in the question box. If you want to chat with each other, you can do that. But you know, if you chat too much, you miss all the wisdom. So it's available to you, but we'll hope to take some questions as well. So tonight, we rotate virtually every year, although we've used some people before. So tonight, let's start with one person you've seen before on our stage, the wonderful Joan Biskupic, who is the Supreme Court analyst for CNN. You see her all the time. Hi, Joan.
Hi, Thane.
Welcome.
Thank you for having me. Thanks.
We always love hearing from you when we see you on CNN or at FOLCS. Next is Dean William Treanor, who is the Dean of Georgetown Law School, the Law Center. There's Bill. He's also a longtime constitutional law scholar. And there's something you should know. He is, I would say, at least the co-founder, if not full founder, of this very organization, Forum on Life, Culture, and Society. Started about 17 years ago when we were at Fordham Law School, and he was the dean there before he moved to Georgetown. I also think he's kind of the Cal Ripken of deans. I think he's the longest serving dean of a law school in the United States. I think I'm right about this. And that's impressive. Also, although I'm not sure it's politically incorrect to say this now, but he's, one of our founding fathers. And so, Bill, we credit you for this. And we've named a bridge after you.
Well, thank you, Thane. It's amazing what you've done over 17 years. You've made such an incalculable contribution to our culture and our discussion about law and life. And I'm really delighted to be here.
Thank you, Bill. Our next guest is the great, terrific Robert Barnes. You've read him almost daily at the Washington Post. He's a legal affairs correspondent, but he principally covers the Supreme Court. And I know from my own reporting at CBS News Radio, I always have to read Barnes. I need to know what he's thinking. So he hasn't been a guest yet. We've been looking for him for years. So Bob, welcome. So glad you could join us.
Thank you for having me. Very nice of you to say that.
It's all true, Bob. And last but certainly not least, the wonderful Tiffany Graham, who was with us last year. Tiffany is here at Touro, at the Touro Law Center. And she is also an associate dean at the Touro Law Center. And she was with us last year. We always like to have one of the Touro people here. So she had so much fun. She was so terrific. We brought Tiffany back. Tiffany, welcome, and thanks for showing up again.
Thank you for having me.
Great. So let's start. Before we get into some of the cases, we always do this sort of, the politics of the court, which everyone seems to be interested in. You're not allowed to say it, but it's true. So let's talk about some things before we get to the cases. For instance, this is through the pandemic, the second year that we've done oral arguments telephonically, right? It was sort of extraordinary. It changed the entire culture and rules of the court, where instead of seeing the justices interrupt each other, you saw each of them ask questions in order of seniority. And that was interesting because Clarence Thomas historically never asked questions when it was live oral argument, and now he has to because it's an order. It comes to his term. So question, I know something that Joan wrote that I thought was interesting in CNN.com, where she said that one thing that happens with the telephonic oral arguments is that the justices don't read their dissents from the bench. And she said that one of the things that was true of those reading from the bench is that the justices oftentimes use that occasion to snipe at each other, to display some, dramatic facial expressions, which you can't pick up on the telephone. So I wonder two things. One, Joan, do you think that this is a real loss for people who were in the courtroom to not get to see the faces of the justices reading their dissents from the bench? And the second thing is, you seem to be saying that this year, even in their opinions, that there was more antagonism towards each other, that you actually felt that you heard more recriminations, even questioning motives, I think you wrote. So maybe you can help us understand that.
Sure thing. Thanks again. And those are two different strands I pointed out. Briefly first, about what we lose in the courtroom during oral arguments and during any kind of oral reading of both the majority and dissent. There's so much more drama that any observer in the courtroom can get. And I think that the justices themselves really felt like they have been denied a key part of their process. They develop lines of argument during oral arguments, each of them jumping in on each other to try to develop the strengths and weaknesses of a case. So we've lost that. But what I was referring to about the dissents from the bench, and a good example would be the very last one any of us heard, and that was in June of 2019, when Justice Elena Kagan dissented orally to Chief Justice John Roberts' decision removing judges from any kind of partisan gerrymandering cases. And she read this very sorrowful dissent about what the cost was to democracy. And I thought that, for example, on the last day of the term, when she dissented to Justice Alito's scaling back of the Voting Rights Act, she probably would have read that from the bench. So we missed those moments. And then to the second part of your question, I did a story about what I was detecting in written opinions. And I think this is actually a new phenomenon. They have complained about each other in opinions. They have just called each other, wrong in their reasoning. They have questioned citations. But I am seeing a new pattern of second guessing their motives. And the first one I observed that in was the Torres Madrid police incident case, where Justice Gorsuch accuses the chief of ruling in a particular way, in part because of new awareness of policing methods. And he doesn't use the phrase Black Lives Matter, but he talks about this new awareness and suggests that the chief in some ways might have taken a path just because of what's going on in the contemporary world. And then Justice Kagan and Justice Kavanaugh got into another similar episode in the Edwards versus Vinoy case, when she accused him of judicial scorekeeping, and he was referring back to a ruling that she had dissented in earlier that was in play. So I was sort of trying to bring together two separate strands and two separate stories, but you're right to mention that even though we can't see them, we're certainly hearing them in various respects.
So a second sort of preliminary question. Justice Barrett, how did she do? Let me start with this question. A year ago, when a little more than a year ago, when she was first nominated during her confirmation hearing, everyone talked about how she had written, when she was a law professor at Notre Dame, critical comments about Obamacare, specifically Roberts' majority decision that introduces the Commerce Clause as an argument to actually preserve Obamacare. And so everyone said, oh, forget Obamacare. If you get Barrett, it's dead. It's dead on arrival. And yet she voted 7-2 with the majority to preserve Obamacare. So one question I would ask for both Bill and Tiffany, is this sort of a reminder of some kind that you don't look at what law professors write and decide based on something they wrote that that's going to be the way they would rule if they were elevated to the Supreme Court of the United States? Is that sort of what she was saying? Or are you saying, well, there's actually something special about this, the way they ruled in this most recent Obamacare, that allowed her to vote in the majority at 7-2. But if it was based on something else, she might have voted elsewhere, because, you know, a year ago we were told this is the end of Obamacare, and she voted with the majority.
Tiffany, you want to start and I'll go next?
Say that you shouldn't read too much into the ACA case simply because it was decided on procedural grounds. I mean, it was decided on standing grounds. And so given the fact that she didn't have, I suppose she could have reached for some kind of substantive grounds to argue in favor of overruling it, but she doesn't strike me, after observing her for a year, as being that kind of jurist. If the opportunity presents itself, it wouldn't surprise me if she ruled to overrule it, but I wouldn't say in this particular case that she fairly felt that the opportunity presented itself. But what I will say is, I don't think that you can necessarily disregard what her convictions are as they have been expressed in the past. And I think that is probably most clear, at least to me, in the religious freedom cases, even though we have not seen in the shadow docket cases like the Tandon case, for instance, or the case, I'm blanking on the name, of course, the case that came from New York. We didn't see her specific writing, at least to our knowledge, in either of those cases. She certainly voted with the majority, which is consistent with what we understood of her position on religious liberty. And so I think that there is a degree to which the jury is still out on her, but it's not completely out on her. And we had a very decent sense of where she would land based on what she wrote as a law professor.
Bill, do you have anything to add to that?
Yeah, no, I mean, I think that's right. I mean, I think her writings as a law professor gave us a sense of where she'd be. But the Obamacare case was very interesting. So, you know, so for those of non-lawyers in the group.
No, we'll get more into that. I mean, we'll get into the specifics. I'm just sort of curious. You can jump in if you want with that. I was thinking, is there something we could say about her more generally, right? Her performance over the course of a year. We were told also that she would be part of a new conservative bloc. She would, I know Joan wrote about this, that this was supposed to be the, you know, theoretically the end of Justice Roberts' influence, because
Wait a minute, wait,
not that you said that.
I never wrote that.
No. The argument, not that you were, clearly, the reason Joan jumped at that is because she wrote a biography of Roberts.
Yeah, I still consider him very relevant. Okay,
Yeah.
thanks.
Right, but there were people who said, that said that Barrett would now that she was on the court, the 5-4 swing vote that Roberts had occupied might now be hers if he doesn't vote along with them. So do you have anything? You can get into the Obamacare case if you wish, Bill, but we can talk broadly.
But I mean, just broadly. So, you know, one of the things that I thought was very interesting was, you know, as Tiffany said, in the Obamacare case, it was decided on procedural grounds, right? But Thomas, in agreeing with the procedural, you know, Justice Thomas basically said, but, you know, the initial decision was wrongly decided, right? And it was interesting to me that Justice Barrett did not join on the concurrence. And I mean, I think that suggests, you know, she just had, you know, signed on to the majority opinion, which was all about standing. So that suggests to me, I think there are two things that I would suggest, you know, we're starting to see. One is, you know, Joan talked about the tension that we're seeing on members of the court. You know, at least I don't see that in Justice Barrett's opinions. She seems to be very concerned with, you know, making sure that she's kind of part of a gentility on the court. So that's the first thing. The other is, you know, and again, Joan's book, everybody should buy it. So I mean, if we're gonna have a takeaway for this evening, everybody should buy Joan's book. But, you know, I'm wondering if what we're going to see is almost three wings of the court. You know, the three Democrats, the three kind of moderate conservatives, and I would say Roberts, Kavanaugh, Barrett, from left to right, but all kind of conservative. And then Gorsuch, Thomas, Alito, with Gorsuch to some extent being he could go to the middle, he can sometimes go to the left, but that is the basic
So,
structure.
so do we think then that for Trump supporters who would say that his most crowning achievement was his 3 appointments to the Supreme Court, that it is interesting, I think Joan wrote this too, and I think Bob has written this, that it seems like 2 of the 3 are more moderate when it comes to their, so far in their judicial philosophy, that it's only Gorsuch, according to what you just said, Bill, that we're seeing in that more conservative bloc.
No, I don't think I would say that they're more moderate. I think I would say that they take more of a go slow approach. They're not ready for the big swing yet. They're not ready to overturn precedent right away. They've got a lot of time. Justice Barrett has not seen her 50th birthday yet. She's got a lot of time on the Supreme Court to do the kinds of things that she might think the court needs. And so, I do think that Trump supporters will not be happy. I mean, one thing, we sort of leave out of this term is what the Supreme Court didn't do, which is it didn't take any of the Trump election cases last year and early this year when there was a lot of pressure to do it. And the 3 Trump nominees were solidly in the silent majority on that, not saying anything and just not taking those cases up. And
But
so
is that because, I'm just sorry, because I think a lot of people are interested in that, and I hadn't planned on discussing it, but since you mentioned it, Bob, is that because they didn't want to be seen as, stooges? They were put on the court specifically for this moment to rescue their guy, their patron? Or do you think, because, it seemed to me that Alito and Thomas felt more strongly that there were some constitutional questions about this last election. And you really
well, I'm not sure that they thought that. They thought that the court might have to take the case just because of the way it arrived, but not that they thought that there was a good argument there. I think you might be hard pressed to find people who thought there was a great legal argument there in those cases that the court was asked to take. And so I think it just wasn't there. But, yeah, of course. I mean, in all previous cases where sort of presidential power was at stake, the justices who were appointed by the president, who was in the thick of that, went against him. And I think that there is some pride on the court in showing an independence of the person who put you there.
All right, one last question before we get to the cases. One last one. Breyer, pressure, I mean, he's an older man. Leave him alone. Do you think it's okay to pressure a man to retire? Nobody likes to be pressured into retiring. It sends a message. I understand, the politics of the court. He surely understands. Remember, I don't know if our audience remembers, we discussed this, Joan, you might have been with us a few years ago when we said, people were pressuring Justice Ginsburg as if, come on, Obama's got a year left, give him a chance to pick more people. Does anyone have an opinion about, what they think Breyer would do, should do? Does anyone think that what Bob said, that Barrett hasn't even celebrated her 50th birthday yet? Wouldn't it be great to get a Democrat who's in her mid 40s now? What should Breyer think? Yeah, Bill.
So, I mean, actually, I'm interested in hearing what the other panelists say, but, when you think about longevity, I always think about FDR. So FDR had an opening on the court, and Felix Frankfurter was pushing Learned Hand, who was the great judge.
On the Second Circuit.
On the Second Circuit, right? And FDR said, you know what? He's 72. He's too old. I'm going to pick Wiley Rutledge, who's 56, right? 6 years later, Wiley Rutledge was dead. Learned Hand was on the Second Circuit for 20 more years, right? So,
great anecdote.
Yeah, so, I mean, Learned Hand, at the time was 72, Breyer, 72. I'm thinking, 82 may be the new 72.
Thane, I think he can. I think he's aware of the pressure, but he's going to do it on his own terms. And we have seen no sign that he's going to go this summer. That could change, but I don't anticipate it. And I think the more likely result will be that he goes next year, because he is aware that the Democratic Senate would be more useful to Joe Biden to push through his appointee. But I think he believes that he has until next year, even though it's a very fragile majority. And what's he going to do? I mean, he's not going to. They had a billboard circling the Capitol, saying "Retire Justice Breyer," and I think he considers that the price of doing business in Washington. But he's obviously not been swayed by that.
And look,
Okay,
he was,
go ahead.
he was the junior. He was junior to Justice Ginsburg his entire long career on the court. He finally is sort of the senior member of the liberals. He's gotten great assignments. He's taken the dissents that he wanted to write. I think he likes it. And so he wants just a little bit longer to do it. Now,
Hey,
maybe he'll
Tiffany,
do it tomorrow. Who knows? We check
Go
our
ahead,
phones all the
Tiffany.
time.
Likes it is great, but I also think that it would be wonderful if he would consider, number one, the interest in preserving, preserving at least 3 members of the court who are consistent with his ideological bent. 2, considering the fact that if something were to happen to one of the Democrats in the Senate, the majority is gone. And someone could get hit by a bus tomorrow, and that's it. And Mitch McConnell has as good as said he will not confirm anyone, regardless. I mean, the risk that he's running is extraordinary. And so I think that it's incredibly partisan of me, frankly, to say that he should retire. I also think that it's incredibly realistic, thinking about it from the perspective of what he might want to preserve from the standpoint of the particular political calculations that exist today.
All right, let's start with the cases. We'll start with the Obamacare. Bill, I'll start with you since you wanted to jump in, so set us up with this. I know everybody wants to talk about it. I mean, and essentially, remember going back the first Obamacare case before the Supreme Court, Roberts wrote the majority opinion in which he basically said that the individual mandate and the tax penalty that comes, remember the idea was that if every individual was mandated to buy the insurance, right? So that's why it's called the individual mandate. And it was there to force people to be in the Obamacare system. And if you didn't jump in immediately, there would be a tax penalty. And it was Roberts who originally said, and you can read this in Joan's book and in Roberts' reporting, Bob's reporting, that he said, look, the Commerce Clause gives the power of the government to tax. And so this is just a tax. And so because it's a tax, it's constitutional. Conservatives were very upset with him. But then a few years later, Congress modified the law and removed the penalty. So the tax is there, but the tax is now 0. So the case really was about, does Obamacare survive if the tax penalty is 0? And the Supreme Court in this instance essentially ruled on the basis of standing that the states that brought the suit didn't have standing because it was 0, there was no penalty for them. They were not actually harmed. So you take us through this a little of your analysis. I mean, the thing that I don't really understand is the point that I think you and Tiffany were originally making. If they really wanted to dispose of this, the conservatives simply could have said, it's now unconstitutional. Forget standing. It's just unconstitutional, or they could have said it is constitutional, that it could, without it or with it, that they didn't really tell us anything, and they didn't give us a sense that there won't be an Obamacare 4 case, the 4th case, before the Supreme Court.
Yeah. So again, there are a lot of things in Obamacare, but among other things, your child gets health care insurance until 26. If you got a pre-existing condition, you can't be denied coverage because of that. So, I mean, there are very important things about Obamacare. And in fact, the things that were really most popular, are preserved even when the tax is done away with. So this is a case in which, states and a couple of people said, we're hurt by Obamacare. And the majority of the Supreme Court said, no, you're not. You don't have to sign up. You don't have to get the insurance because there's no tax. So, there's no harm. And if there's no harm, there's no standing. which I think is, I think that's absolutely right. Again, what was really interesting to me about the case was, first of all, that Thomas concurred, with Breyer's majority opinion. And he basically said, look, we got it wrong the first time, but this is just about standing. And there's no harm, so there's no standing. I think Alito and Gorsuch, who were the dissenters, the opinion's kind of snarky. And it's just very strong. And what really is, we got this wrong the first time. And when we're looking at standing, we should keep in mind that this is all just unconstitutional.
Tiffany, maybe you can help add to this a little, because I think most people who are civilians don't really understand this idea of how the Supreme Court seems to have a love affair with procedural decisions, right? That if they can get rid of the case on a procedural ground, way better. And it doesn't really, it's just interesting because I think it doesn't, for people looking, well, what is the law, right? Then what does it really mean if you're trying to get rid, why don't you just tell me instead of getting rid of it on the most narrow grounds? I think people are frustrated by that, don't really understand why it's done that way.
I think there are a lot of ways you can think about it, but one of the most helpful ways for me, at least, is to remember that this is John Roberts' court. And John Roberts is very much an institutionalist. And when he was being confirmed, he talked about balls and strikes. Now, I don't happen to believe him entirely with respect to the whole balls and strikes metaphor, but I will say this, especially when you look at many of the decisions that came down this term, I do think that there is an effort to try oftentimes to issue decisions that are going to create the most stable majority possible, in part so that the country doesn't erupt. I think that one of the things that's interesting about John Roberts, at least from my perspective, is his recognition of the court both as a judicial institution, but also as a political institution. And when you resolve questions on procedural grounds, you can put off until another day the substantive fight. And if you can do that, the fact that you can do that, it just takes the heat out of a question. And that's actually beneficial as far as the court is concerned, because even though there are people who are frustrated with the court, if they're frustrated with the court, they're probably not angry with the court. And that's a better outcome.
Well, reporters hate cases decided on standing because it's so hard to explain, and it does, you're right, it doesn't get to the real issue. But I thought that Justice Breyer, in his opinion, explained it as this is judicial modesty. If we don't have a real controversy in front of us, if we don't have a real case, then it is not up to unelected judges to undo what elected members of Congress did. And clearly, Congress, it was hard to pass Obamacare. It's been even harder for them to undo it themselves. And I think the court is saying, it's not our place to do it. You guys can do it if you really want to get rid of it.
And just to pick up on what Tiffany said about the chief, look what he does this time. In 2012, he keeps the opinion for himself. 2015, he does the same, both times upholding Obamacare. This time, he gives it to the senior liberal. That was his assignment, to give it to Justice Breyer. And he decides to, again, sort of imbue the whole thing with some integrity, cross-ideological consensus here. He'll do it. He personally is not as invested in the issue of Obamacare as he is in things like voting rights, big campaign money, the partisan gerrymandering, Cedar Point unions. That's where you see core John Roberts as a conservative in an ideological vein. But this is one of those cases where you do see, as Tiffany said, his more institutionalist side come out.
So speaking of vote,
I just want to say, about Roberts really conveys the sense that in the first Obamacare case, what really drove him was trying to preserve the sense of the court as apolitical, and, that it was not an issue that he really cared about so much either way. But, the sense that, that a Republican justice would strike down the signature achievement of a Democratic administration was something he just didn't want to do because that would undermine the integrity of the court.
Mhm. All right, so speaking of voting rights, let's talk about the Arizona voting regulations case that was decided last week. This is have a huge impact because we know, I think is it on 800 pieces of legislation in 49 different states that will be changing election laws. This dealt with two specific changes that the state legislature of Arizona made. One is to say that we disqualify your vote if you vote in the wrong precinct. And secondly, when it comes to having your vote picked up, you can't get it picked up by anyone else other than your family or someone who's your caretaker. You just can't give it to some third party because who the hell knows what he's going to do with it, right? So that was purportedly the argument in the two, and the Supreme Court essentially said, well, this is not unconstitutional in part because we don't think it violates the Voting Rights Act or for that matter, the 15th Amendment, because it's really, I think they said, it's really more like an inconvenience. It's not a denial of voting, it's an inconvenience of voting for the purposes of voter integrity or ballot integrity. Because this is such a loaded question, and because it's going to affect all the battleground states, and this is not going away because absentee balloting is here to stay. I think this is really important to explain, you know, what the Supreme Court did, why this is, for some of you, this may be classic voter suppression. And for others might say, I don't know if anyone's here might say, well, look, you know, the Voting Rights Act was for things like poll taxes and literacy tests, right? I mean, for some serious, true deprivations of voting. And these things that we're seeing state legislatures doing, which they are authorized under, what is it, Bill knows, is Article 1, Section 4 of the Constitution, right? It's state legislatures who set the rules, the time, manner, and place of voting, and it's their job, and leave them alone and let them do what they want to do unless they actually deny people the right to vote. So I'm going to leave this open now because I assume there's much to say. Joan, you want to start maybe, or Bob?
Well, I'll start by reminding everyone what Attorney General Merrick Garland said just 1 week before this case came down, when he announced the lawsuit that the federal government was bringing against Georgia for its new voting restrictions. And he said he fears that millions of Americans are going to have a harder time voting because of these laws that are coming into place. So that's the backdrop. It's not, we're beyond the era of poll taxes, as you say, Thane, but there are other ways that states are pecking away at the franchise. And that's the overriding concern here. Now, the Biden administration did not think these two laws in Arizona were so egregious that the administration even said that they should be struck down. But the administration did not want to buy into a standard for what's known as Section 2 of the Voting Rights Act, which was at issue here, that would make it harder for people, mainly racial minorities and advocacy groups, to sue these states for these infringements on the vote. And that's exactly what the Supreme Court did by a 6-3 vote, a very clean ideological vote, with the chief assigning the decision to Samuel Alito, to say that essentially, if it's something that is just sort of the usual burden of voting, that is not going to be a problem. And when you're looking at disparate impact between white voters and Black voters, you really need some very strong evidence that somehow there has been a different result for racial minorities. And Justice Alito laid out several, what he called them, guidelines rather than an actual test or standard. But taken as a whole, as Justice Kagan said in her dissent, all those factors will make it very hard to bring these Section 2 claims. And just one last piece of context, this all occurs in the wake of the 2013 Shelby County versus Holder case, in which the justices removed another part of the voting rights law called Section 5 that required states with a history of discrimination, and Arizona was one of them, to pre-clear ahead of time any new voting rule. So all these new voting rules are in place without any kind of Department of Justice supervision. So people are having to come in after the fact to sue. And the Supreme Court has now kind of hollowed out that remedy also.
Okay, anyone else? Tiffany, you have something to want to add? Or we can move on to another case?
I would say that the one last thing that I would add is it's really discouraging that, number one, the court has put the thumb on the side of the state with respect to the interpretation of a statute that was meant to protect the rights of individuals. That's one thing to keep in mind. And number two, I think it's very important to keep in mind what Justice Alito said hypothetically about fraud claims. He made the statement about the state potentially wanting to protect its processes against fraudulent efforts by voters, et cetera. And one of the things that has been fairly clear is that voter fraud is vanishingly rare, and yet it was the rallying cry after the 2020
But was it Alito or someone else? I guess I can't remember whether there's a current opinion who said, yeah, but even if there's no fraud, it's important for the public to believe that there won't be fraud. In other words, does anybody buy that to say, look, you know, I don't need to see evidence of fraud. I just think it's really important with absentee ballots that people believe that every policy is implemented, every regulation is implemented to assure ballot integrity.
I think the more important thing is what Justice Kagan said in her dissent, which is if there's a disparate impact on minority voters, and if there are multiple ways of ensuring that fraud is not occurring that don't require the kinds of steps that have been taken, that have been challenged in a particular case, then why wouldn't you actually follow those steps? I mean, it's just really unfortunate that as a result of this case, that the voter fraud allegation is one that it seems at least will be presumptively acceptable to the 6-3 majority on the court.
Right. I mean, if you look at it, this is really a balancing test, right? On one side is fraud, but there's no evidence of fraud. You know, they're just saying, oh, we're afraid of fraud. You know, and then on the other side, you know, there's good evidence that it has a disparate impact. You know, that it significantly increases the number of ballots of Black voters and Latino voters that are thrown out. And Justice Alito's response is, well, there are not that many that are thrown out, but there are a lot more of, Black and Latinx voters, right? And then, on the Native Americans, what Justice Kagan says is, on Native American, it's often, people live 2 hours from the post office. So, having somebody who takes your ballot to the post office, that's really important.
Right.
And Alito's response is, well, your post office is supposed to be nearby.
Right. Doesn't really answer that.
That's not a response.
Yeah. Bob, let's talk about the Catholic adoption case. 9-0. All right. So this is the case where Philadelphia has contracts with a lot of agencies that will help with foster care and adoptions. And one of them, in this instance, the Catholic adoption agency, had never actually rejected foster care or adoption for a same-sex family, but they said that if everyone came to us, we would not work with them. And so immediately the city of Philadelphia said, well, you've now essentially violating our anti-discrimination laws, so we're not going to contract you with anymore. In this case, went to the Supreme Court. 9-0, right? 9-0. Liberals voted as well. This is interesting on many levels, because remember, this conversation got started years ago at Law and Land when we talked about the Colorado master cake case, right? What's the significance there? Well, that the First Amendment's free exercise of religion clause can be used, the religious liberty argument could be used to challenge the right to privacy. And that more and more we would be seeing people that are objecting on social issues to lifestyle choice, whether it's sexuality or marriage, that they could reject it on religious liberty grounds. And it seems like that's what happened here. Now, again, it's confusing because didn't the Supreme Court also just refuse to take up a case with a florist or a photographer? So what does this do? Right? Does this make you think that as we move forward, same-sex marriage is in trouble because anyone who's claiming a religious objection actually has precedent now, 9-0 in the form of this Catholic adoption case?
No, I don't think same-sex marriage is going to be in question. I think the court has done that and moved on. But this is a big clash between religious rights on one hand and anti-discrimination laws on the other. I think it's very clear with this court, even though they haven't quite brought themselves to say it, that religious rights are going to win this fight. They ruled for Catholic charities on a pretty obscure part that there was an exception in the law that could be used. And so it was wrong for Philadelphia not to extend it to Catholic services.
But also, wasn't there, Bob, the argument also, I just want to make sure the audience knows that the court said, well, you know, but there's so many other we have contracts, the city has contracts with all these other providers.
Yes, it said that no one was denied a service because of this, because there were others who were willing to provide it. But, you know, if you think of it as a public accommodation, that's not the rule.
Right.
The rule has to be provided to everyone. But I think it was very clear from that they're still putting off this decision and perhaps don't want to make it. That's certainly what the concurring but kind of dissenting conservatives were saying in that. And that, you know, I think we've sort of seen it. Now, it is interesting that they passed up the florist case. It's a case that's been around forever. It's a woman from the state of Washington who refused to make floral arrangements for someone who she said was her longtime friend, but he was marrying another man. And so that case has been waiting and waiting for all these others to be decided. The court makes this decision and then says, we're not going to take this case. So I think that the court is not ready yet to sort of take the plunge on this.
And what, you want to add to this? Yeah.
It's important to be careful, though, about assuming what the court will do when faced with anti-discrimination law, because I'm not entirely convinced yet that if they are faced squarely with the religious organization that wants to discriminate on the basis of race, that they're going to say, yes, you can. They might, but I'm not sure yet. But what I will say is, after paying attention to what the court has been doing all year long in the establishment of something that's coming close to a mandatory accommodation regime for religious claimants, in effect saying if there is an exemption that exists in a secular law, then that exemption has to be presumptively available to religious claimants. And if it's not, then state has to come up with a very good justification for why it's not. That's going to create a bit of a mess. And so we'll see how that plays out. I mean, that played out in this case. It's been playing out. It played out in the COVID cases, and we'll see what happens in the future. I think that the race example, and it's going to come, is going to be very difficult. But I think that I think you're right when it comes to other protected classes. But when it comes to race, I think that they might blink in that case.
No, I was definitely talking about gay rights.
Yeah, he was
there.
So let's move on. This was my favorite case, and I want to make sure we get to this. This is the cheerleader case. This was in my mind.
Are you going to say the bad word, Thane?
No, but not because we're bound by anything, Bob. But I hadn't thought about that. Thank you. Maybe I'll consider it. So this was a cheerleader who went on an Instagram rant. She didn't get on the varsity cheerleading. She was on the junior varsity cheerleading. She was really pissed off, right, Bob? And
Yeah,
then she
go
went
ahead.
on an Instagram rant, which remember from Instagram, for those of you who are on social media, it doesn't last very long. It actually disappears. Someone took a screenshot in which she went F-bombed on everybody at the school, right? So, and it was about cheerleading. She wanted to, but she did it from her private phone and she did it off campus and not during school hours.
On a Saturday.
On a Saturday, thanks, Bob, right, on a Saturday. And the Supreme Court essentially said, well, this doesn't fall into the category. I mean, we know that students don't lose their First Amendment rights simply because they go to school, but when they go to school, they're expected not to engage in disturbances. You know, kids can't just make a speech while the teacher's talking, right? You know, because they say, I have a First Amendment right to make a speech. No, you don't, because the teacher's talking. So the question is, as Bill said, balancing, right? What disturbs the school day and what's really, you know, a statement that should be protected. Remember, this is a public school. Because it's a public school, the First Amendment absolutely applies. So here they said it's a private phone, it's off campus, it's on a Saturday, the thing disappeared. And so that, it was certainly no disturbance. And so they, you know, they said essentially her First Amendment rights. She's long gone from school. I think she's now 22 years old. This happened when she was in 10th grade. I don't know who wants to start with this, but the question I have is this, and it's partly because I just wrote a First Amendment book, that this issue really interests me, which is, and Bill is a legal historian, so he should really answer this, which is, if James Madison was here today, right, and we showed him this rant, and we showed him the Supreme Court decision, wouldn't James Madison turn to us and say, well, there's no way I thought that the First Amendment's free exercise of speech meant that. I was talking about public forums engaged in representative democracy, raising issues about the political urgencies of our time, where people become better informed citizens, participate in our democracy. I mean, I'm sure, wouldn't he say that? Why is that protected speech?
Right.
I'm not going to throw the F-bombs, Bob, but I am wondering when you're saying, is this really something that's so necessary to protect? You know, just because it was off campus on a private phone? Is saying, if the kid said something, remember, this cases started with kids wearing armbands during the Vietnam War, right? That's how it started. That's important. That's just saying, yeah, we're not going to stop kids from wearing armbands, but this seems like a real, you know, devaluation, disrespect to what the notion of political commentary is.
Right. No, I mean, I think that's right. You know, Madison was concerned about political commentary, but
Sure.
that train left the station a long time ago. You know, we have.
But why did it leave the station?
I think, you know, because it's, among other things, it's hard to draw the line between what's political and what's not, right? So, I mean, like, this is an example. So, for, you know, she's criticizing the school. You know, she's saying the cheerleading squad, you know, that there was an 8th grader who was put on the cheerleading squad as opposed to I am the other 9th grader. And that reflects an injustice and unequal treatment, right? So, I mean, so, you know, one of the things that's really in Breyer's opinion a little bit is, you know, this is a commentary on the school, you know, and, you know, you may feel like this is not the most momentous, but it, you know, it's a commentary on the school, and, you know, why should you decide what's momentous as opposed to, you know, what's epiphenomenal. The other thing, though, that I think the court is struggling with is, you know, in the world of social media, you know, it used to be there was a difference between what you did off campus and what you did at the school, right? So I can't interrupt, you know, you're teaching con law, you know, and I can't start in your class, can't start spouting off something irrelevant because that's disruptive to the on campus. But, you know, 30 years ago, if I did something off campus, school has no interest in stopping me. But now with social media, the line of bullying, you know, is, you know, it's things occur off campus that have incredible consequence on campus.
But didn't Barrett actually, am I wrong here? Didn't Barrett have a concurrence, or did she join it? Didn't she actually also say this shouldn't affect something else like school shootings and bullying? Like, for instance, off campus with your phone, if you're bullying or threatening to come into school the next day to shoot everyone up, that's clearly not First Amendment protection. But right?
So,
Oh,
but I,
you're saying she didn't write separately, but she brought that up during oral arguments, as I'm
Oh.
sure Bill remembers. In fact, just to go back to what you were saying about James Madison, these 9 justices, all, overachievers and winners in so many ways, during oral arguments, so many of them were sympathetic with the fact that she did not make the varsity squad. They really sort of picked up on her frustration, so they got it. And
So you're saying they didn't say, why didn't she just write an op-ed in the school
no,
newspaper?
no, they were with her. And to your question about the whole bullying, the opinion by Justice Breyer here makes the point that this bullying is a separate thing. And during oral arguments, you're right, Justice Barrett mentioned that.
And I also think it's worthwhile to point out that if this speech arguably should have been protected on campus. I mean, she wasn't trying to bully anyone. She wasn't threatening anyone. She wasn't harassing anyone. I mean, really, to my way of thinking, it was very much in line with the famous F the draft case, Cohen versus California. It was incredibly emotive speech. And so I think that perhaps in the future, the court will take another opportunity to look at this kind of speech on campus, but the fact that it was vulgar speech should certainly not have presumptively stripped it of protection if it had happened on campus.
Yeah, I would just add too, the court doesn't take a lot of these student speech cases, but this is the first time since the sort of landmark case 50 years ago that the court sided with a student. In all the others that it's taken, it has sided with school administrators.
And you know how I know that, Bob? I read that in the Post from you. No, I actually, honestly, I didn't know that.
And once in a while, I remember what I wrote too.
Yeah,
It
normally
doesn't happen that often.
Normally I call up Bill Treanor, but in this case, I just happened to be reading the Post. Let's talk about the California donor disclosure case, because that also, I think, deals with, the issue of campaign finance reform and issues of elections, because everyone has elections on the mind. This is a case where it says, well, California had a regulation that said that if you're a nonprofit, you have to tell us who's donating to you. And the Supreme Court said, no, you don't, because that violates the donor's First Amendment rights, that they have the right to both speak, more importantly, to associate without being punished for their associations, right? We know in the age of social media, you could be canceled in an hour, right? So if someone finds out that you wrote a check to something that everyone now doesn't like, the consequences could be severe. So the Supreme Court said, no, this is a First Amendment issue. There are others who are saying, no, this is really about, transparency and recognizing, the whole question of how campaigns and elections are run and won. Anyone have any thoughts about this case? Oh,
No,
good.
I mean,
We can move to another one.
Yeah, I mean, I think you're right that, the two, the California case and the Arizona case as a pair are very concerning because, they go after, will courts look at, discrimination in voting regulation, which is what we're seeing now across the country, right? And then, one of the few elements of campaign finance law that's still in place is the disclosure about gifts. And as Justice Sotomayor says in her dissent, that's now in the bullseye.
Yeah.
It's hard to see how that could be upheld after this decision.
After this. Mhm.
So, I have to say, I don't think the majority's argument, I don't think it's frivolous. I do think, I do get the concern about, being publicized that you're supporting, a particular charity or, a candidate. But at the same time, the voting issues are really crucial. And this again is really kind of gutting the integrity of the voting process, where you can have dark money floating through and nobody knows about it.
The California.
The other thing about this, can I say just one thing to add? This is one where the chief, in his opinion, he could have gone narrower. He could have, there were all sorts of ways to take a bit of an off ramp to say, in an as applied challenge, we'll side with these two groups, or, or in some way have cabined the ruling. But as the chief has done in other areas of the law, but not this one, This was very sweeping and will have great consequences.
The California farm workers case, the union case, I know Bill is interested in this because Bill is a living expert on the takings clause. And so he's going to have some interest in this. But this case is interesting, right? This is a case that says that the unions for farm workers in California have a right a few times a year to venture out onto the property of the farms in order to solicit the farm workers for them to join the union. And the farmers, or the corporations that run these massive farms, agri farms, I guess, said, yeah, but this is a taking of my property under the Fifth Amendment. You can't take my property without just compensation. So this is an interesting case because this isn't, and I start with Bill, I guess, this doesn't look like a taking. It looks like a temporary taking, and it looks like the Supreme Court said, oh yeah, temporary takings are also takings. So what's the rule on this? Because this just, I think, is very confusing. It seems like it's a decision that really just supports big business.
Yeah, I have to say, I mean, I think, by and large, I think Chief Justice Roberts' opinions, I don't always agree with them, but I always think they're incredibly well-reasoned. I don't get this one. The test is it a permanent physical invasion, right? So this is a case in which in 4 months of the year, the organizers can come on the property 3 hours a day, an hour before work, at lunch, and an hour afterwards. How is that a permanent, invasion? It just, it really doesn't, it just doesn't work in terms of the precedent. And I think it suggests a favoritism towards big business that, we're seeing in this one case in particular, but I think it's going to be a harbinger of what we see in the future.
So
Bob?
religious organizations win at the Supreme Court, unions lose right now. And so if you're going to draw a sort of general rule, that's one I think that you can draw.
All right, let's try to get to quickly 2 of the cases that are coming up next year, both blockbusters. Let's see how quickly we can do that. We'll take a couple questions from the audience and we'll say goodnight. It was a very quick and winning and smart and entertaining hour. Thanks, guys. Great. So one case that we know that's coming up is abortion. Huge on the docket. It arises out of Mississippi. Mississippi, this seems to be taking direct aim at Roe v. Wade. Roe v. Wade said 24 weeks, after 24 weeks, a woman has no right to have an abortion because at that point, the child has viability outside the womb. Mississippi basically says, hey, with the new science nowadays, you don't have to wait 24 weeks. In 15 weeks, the child has viability outside the womb. So the rule should now be you can't get an abortion after 15 weeks. I don't know whether this case is also joined with other cases. I thought there was another case in Mississippi that has like a 6-week rule, which is about fetal heartbeats, which is to say, well, shouldn't it just be when you can hear the heartbeat of the child? And at that point, it's 6 weeks, that's a living being. So this is going to be a huge case. The question I have for you is, given the new appointment of Justice Barrett, we know she's a Catholic. We know she's from Notre Dame. Everyone said this. Is Roe v. Wade in trouble?
I think definitely Roe v. Wade is in trouble. I think we have 6 votes on the court that would like to have Roe overturned. I think the chief would like to have Roe overturned, but he's an incrementalist, so he wouldn't do it like in one bolt. I think in some case, it's really a question of where Kavanaugh would come out. Because I think, I think the 4 with Justice Barrett, Alito, Thomas, and Gorsuch, I think are ready to overturn Roe now. And this is a case, it's hard to see how this would be a limiting case. I think this, this really overturns Roe if they uphold the law.
Mm-hmm.
Well, I think that they could say, I think that they could uphold it without completely overturning Roe by the question that they have to answer is, are all pre-viability bans on elective abortion unconstitutional? And if the court answers that question no, then it starts a whole new round of, well, then where do you draw the line? But that's the kind of thing that this Roberts court sort of likes to do sometimes.
The gun control case, the gun regulation case, I think this one arises actually out of New York State. I know there were some justices that have been upset that since the Heller decision, which is 10 years ago, the Heller case, remember, says You have a right to a constitutional right under the Second Amendment to have a gun if you're a law-abiding person and the gun is in your home and it's there for self-defense purposes. And that was the very first time I think that the Supreme Court spoke so emphatically about gun rights under the Second Amendment. But again, very specific, right? In your home, self-defense purposes, and you're a law-abiding person. Some justices have said, how come we haven't taken on any more cases in 10 years? Well, here's one that's coming up. And this is the one out of New York State that says that you can have your gun inside your house, but you can't carry your gun outside, even if you are a law-abiding person. And even if you're saying that I only have a reason to do it in self-defense, I'm wondering whether someone is going to say, you just took $1 billion out of the NYPD. You're defunding my police. There's people getting shot on Times Square. For the love of God, I want my gun in New York. This is like the 70s, baby. It's going to be really dangerous to live here. And I wonder whether that's an argument that this conservative court will find compelling.
Well, I think just the fact that they took it tells you that there's much more confidence on the far right that they're going to get Amy Coney Barrett's vote on this. The reason the justices didn't want to take up any gun cases last term before she came on was that the conservatives could not count on John Roberts' vote. John Roberts was part of the original Heller decision, but he was skittish about going further. But this is one area of the law that now Justice Barrett had written about when she was a judge on the Seventh Circuit. And she had made clear that she didn't think the promise of Heller had been carried through for gun rights. So I think that's why they took it. And I think you're going to see much more limiting of gun control measures.
I mean, I think it's hard to distinguish, the logic of Heller, I think, covers this case. I mean, I would say, though, somebody who studies the original understanding, Heller's an originalist decision. I think it's just wrong. I mean, I think that, there's some evidence of, this as an individual right, but there's more evidence that people primarily thought of it as a militia right. So, to the extent that they're originalists, the right wing, I think Heller was wrongly decided. And if they extend it, it'll be even more wrongly decided.
Okay. One last question from the audience and we'll say goodnight. I love this question. Are you ready? Are there any legitimate considerations on expanding the court? What would that process look like? Where would it start? And what is the pathway to expansion? Those are three really good questions, right? Because we know that it wasn't always 9, right? In the 19th century, were they 5? There were 6. I'm trying to remember. We've been 8. We've been at 11. So how did we get those numbers up and down like that? That's one of the parts of this question. And the second question is, can you imagine a scenario where you say, you know what? Why not 11?
Well, Bill knows this by heart, but I'll just say it's been as low as 5 and as high as 10. It's set by Congress. And it was 151 years ago that Congress set it at 9 and it stayed that way. But Bill, you're the expert on this legal history.
Yeah, so I mean, at the end of the Adams administration, when the Jefferson Republicans are coming in.
We're talking about John, the first Adams.
The first Adams, right? So that Congress passes a statute that says it's 6, but when the next person steps down, we're not going to fill that spot. So, I mean, it was both kind of manipulation of the number and it was very political. So, and we've seen that through our history, but it's been 9 for a long time, and particularly because of, FDR's, attempt to pack the court. There's a sense now that 9 is a sacred number, because it's been there so long. So, I mean, I think as President Biden looks at it, if Congress wanted to make it 11 or 15 or 100, it could do that. But I think it would really, the concern would be whether that undermines the rule of law because it's been 9 so long.
Anyone want to add to that? By the way, does anyone actually think that during the Biden administration, that the progressives who feel very strongly about this will prevail on him to find a way to act? Tiffany?
Absolutely not. I mean, my only thought on this is 9 is not a magic number. It might be something that we've grown used to, but it's not a magic number. The main thing I would say about the legitimacy question is I think that it's wrapped up in lots of legitimacy questions with respect to gerrymandering around the country, with respect to the lack of representation in the Senate when it comes to the representativeness of the Senate. It's all part of a broader picture overall. I mean, there is a general problem in this country when it comes to the representation of interests of people, of the voters in this country, and the Supreme Court is part of that overall story. But I don't subscribe to the idea that 9 is a presumptively legitimate number. It's not, but it is the number that I think is going to stay.
A good way to end for the evening. Thanks, Tiffany. Before we say goodbye to our guests, remember here at FOLCS and at the 92Y, we've been open for business throughout the entire pandemic. And we plan to have more programs all throughout the summer. And of course, starting up in the fall, hopefully we'll be back on the stage of the 92nd Street Y. As you all know, FOLCS and myself, of course, we've had a longstanding relationship with the 92nd Street Y. They're our partners and our friends, and I think they're New York treasures. And so we really, tonight, I think is a really good example of what we're able to do in an hour. I thought this was fantastic. Joan, Bill, Bob, Tiffany, you were all outstanding. You're all such terrific friends and so brilliant and charming. And so I hope you'll come back again. Bob, now that we have you, now you're roped in. I hope you'll say yes again.
Certainly would.
Thank you. So thank you all. I want to say goodnight to Joan and Bill and Bob and Tiffany. Good night to everyone. Stay safe. Watch out for the variant. Keep wearing your masks when necessary indoors. And hopefully maybe we'll see you in the fall on a stage. I'm Thane Rosenbaum for FOLCS in the 92Y. Good night, everybody.